Welcome, everybody. This is today's Tuesday, April 11th, 2023. This is meeting number 4 of the Planning, Building, and Environmental Committee meeting. My name is William Riley. I'll be the chair of tonight's meeting. I'm going to make some comments here. So to members of the public, comments can be made from the members of the public for a matter that is on the agenda by advising the chair during the request to address an item on the agenda section of the agenda. It's a little bit of a mouthful there. The public may also submit comments written for matters that are on the agenda to jdyson@westlincoln.ca before 4:30 on the day of the meeting. Comments submitted will be considered as public information and will be read into the public record. This meeting is being live streamed as well as recorded and will be available on the township website, usually shortly after. So at this point, I'm going to read the land acknowledgement statement. The township of West Lincoln, being a part of the Niagara region, is situated on treaty land. This land is steeped in the rich history of the First Nations, such as the Hattaway, the Haudenosaunee, and Anishinaabe, including the Mississaugas of the Credit First Nation. There are many First Nations, Métis, and Inuit people from across Turtle Island that live and work in Niagara today. The Township of West Lincoln, as part of the regional municipality of Niagara, stands with all of its Indigenous people, past and present, in promoting the wise stewardship of the lands on which we live. So at this point, I'm going to move forward to any disclosure of pecuniary interest and or conflict of interest. Not seeing or hearing any. Rarely do we have a night planning where we don't have any public meetings, so there's no public meetings this evening. And so I'll look at back around the horseshoe here to see if there's going to be any changes in order of items on the agenda. Not seeing or hearing any. We have one appointment this evening, and so that's from Ed and Ken Rosick, requesting for consideration for review and amendment to the Township Noise Bylaw, which is 2013-50. And at this point, I'll ask Ed and Kim, if both of you or one of you, either or, come up to the microphone. And then all I will ask, just for the sake of, for our clerk, if you could just state your name and your address for public record, and then from that point, proceed with your presentation. And then at the ending of the presentation, there is a recommendation, which I'll read to council.
Okay, so my name is Kim Rosick, and I reside at 1 Euphemia Court in Smithville, postal code L0R2A0, and my husband
I'm
Edward.
Ed Rosick, same address.
Thanks.
For now. Alrighty, so. Thank you very much for having us here. We're here this evening because we would like to speak to you with regard to a noise issue that we're having. And if I could ask you for some, I see that, okay, it's a little bit different than mine. We would like to thank Chairperson Riley for having us here this evening, councillors of West Lincoln and Mayor Ganan, and a special thank you to Ms. Dyson for setting this up for us this evening. There is a noise issue we have been experiencing here in beautiful West Lincoln. We feel that our current noise bylaw is not supportive of any kind of resolution with regard to a situation such as ours. Our perception of noise is a sound, especially one that is loud or unpleasant or that causes a disturbance. West Lincoln's definition of sound, according to bylaw number 2013-50, is sound means an activity, matter, thing, or tangible personal property or real property from which sound or vibration is emitted. So you have an idea of what we're experiencing. I see the volumes turned up. So this is the sound that we're talking about. That is a sound bite that was recorded from inside our home. We don't want to repeat that. So the overview of the disruptive sound issue for us, who it's Ed, Kim, and our family, what the noise that you've just heard, where in our community of Smithville, West Lincoln, roughly 150 feet away from point of reception, which is our home, when the noise began in early January 2023 and occurs between 6:15 and 6:45 a.m., but not exclusively, and it's heard from inside our home. Why? The noise is a result of a person starting their vehicle with initial revving while parked in their drive on private property. How? It is a noise that is so explosive it awakens us early in the morning while we are still sleeping. We're retired, so we don't have to get up at 6 o'clock in the morning anymore. Overview of bylaw number 2013-50. Number 3, there's a general prohibition. No person shall make, cause, or permit the emission of sound or vibration at any time, which is likely to disturb the quiet, peace, rest, enjoyment, comfort, or convenience of the inhabitants of the township. 4, limitations by time and place. No person shall emit or cause or permit the emission of sound resulting from any act listed in Schedule A to this bylaw of clearly audible at a point of reception, which would be our home, located in an area of the municipality within a prohibited time shown for such an area as per Schedule A. So this is, again, a screenshot from that portion of Schedule A. Oh, yes, sorry, I'm not a pro. I'm glad you can hear me. So number 6 of the bylaw 2013-50, emitting or causing, permitting the emission of sound resulting from motor vehicle racing. That doesn't fit our situation. Number 7 is a little closer, emitting or causing or permitting the emission of sound resulting from the revving of a motor vehicle engine, urban and rural areas at all times. So number 7 of Schedule A comes close to matching our situation. When starting a vehicle, the engine does rev. That's just a mechanical means for the vehicle to start. The bylaw does not have revving in its interpretation where they define different terms within the bylaw, and we feel that number 7 of Schedule A should include starting of a vehicle. Now, our attempt to resolve the noise issue, we politely approached, or Ed politely approached our neighbor with respect to the noise emission to our home with no resolution. Communicated with Niagara Regional Police 2 times. No resolution, as this occurrence is on private property and Highway Traffic Act cannot be enforced on private property. And communicated with West Lincoln Bylaw Department several times with an end result of no enforcement. And so our basic analysis is there's a gap in enforcement. So we have a noise, we have something that is disturbing the peace and the quiet of the community. NRP enforcement, they cannot enforce the HTA on private property. They cannot enforce a noise bylaw that does not exist. And the same goes for West Lincoln. They cannot enforce a noise bylaw in this situation. So that's the gap. Neither agency is empowered to help us enforce and resolve this unacceptable noise issue. So in closing, in all our decades, because we are older, in residential living, we've never encountered a situation like this. There have been no other vehicles in our community that have awakened us by merely starting their engines in the morning. It has been 10 years since bylaw 2013-50 has been looked at. There is no interpretation or definition for revving in bylaw 2013-50, and basically we're asking that you and staff investigate this matter so that we and other citizens can continue to love and enjoy our unique setting of West Lincoln. And we really do thank you for your time.
Thank you, and I'll just start by saying that I appreciate any time we have residents who, you've done your research, you've exhausted all avenues, and you kind of come up with in the middle of where the gap is. So it's great that you've not only been able to speak tonight, but you had the initiative to bring this forward and help bring this to our attention and bring it to staff's attention. So hopefully we can see what can be done. Okay. What I'll do first is I'll read the recommendation/resolution here to kind of open this up on the floor there, and if we have any questions or comments, that would be the time to do that. I'll read it first, and then I'll get my mover and seconder. So that the correspondence received by Ed and Kim Rosick dated April 11th, 2023 be received, and that staff are hereby directed to do a full comprehensive review of the noise bylaw with consideration to notes and concerns highlighted in the PowerPoint presentation presented on April 11th, 2023, and that staff report back at a future committee and or council meeting with a report highlighting their findings and recommendations. So at this point, if I can get a mover, I got Councilor Rayner and Mayor Ganan as a seconder. And then I'll open the floor up for okay, so I have Councilor Rayner first.
Thank you, Mr. Chair, and thank you for your presentation. This is directed to the Director of Planning, Mr. Treble. Brian, we have that, as this couple brought up, the revving on Section 7 that says at all times in both urban and rural areas. I know it doesn't say starting up, but revving, whether you start up or it's already started and you're revving it, isn't it still revving? Why is it not applicable?
Excuse me, through you, Mr. Chair. We have been communicating back and forth regularly, myself and my bylaw officer, trying to, or at least I've been trying to explore various avenues to figure out how we can deal with it. The challenge as I've found it so far is that, especially in the winter months, idling of a vehicle, especially if it happens to be a diesel, is something that is normal. And often places like other municipalities will have something called an idling bylaw. But idling bylaws are more about duration and not so much about initial startup and warming up period, because that's essential and a certain window of time is allowed. So that just didn't seem to quite fit the concern. I don't think it's revving. I think it's just basically idling from what I can tell. But as I understand it, this particular vehicle has an aftermarket muffler. Where it becomes more complicated in my mind too, and just to put it out there, the Highway Traffic Act applies, as has been noted, and the Highway Traffic Act allows for vehicles to emit, even with muffler systems, up to 95 decibels. So rather than our current noise bylaw that is about whether it's inappropriate at the point of reception, we would end up having to get into the issue of having decibel readers and things of that nature, from what I can tell. And I don't even have a decibel reader that the township owns or anybody with the qualifications to operate one that I'm aware of at this point in time. So there's a bit of work I need to do just to see if there's something else that works. So far, everywhere I've kind of turned just is complicated. So it you know, as mentioned, the bylaw is 10 years old. It's worth a review, and I'm happy to do that and report back what I find.
Councillor has a follow-up.
Yes, through you, Mr. Chair, Mr. Trouble. We've done this in the past where we've researched other municipalities to see what they have and what they've implemented, not just what they brought forward, but what they've actually implemented that have been utilizing. I imagine you would probably want to go through and look at something like that, which you have in your hands, so I shouldn't have said it because I already know you would have done that. But the other thing is, and I think it's very important, and this couple is exactly correct, whether you live in town or you live out in the country, you have a right to the enjoyment of your property. And if somebody next door is, or down the road, because sound travels, is making a lot of noise, that's very irritating, you shouldn't have to tolerate that and ruin the enjoyment of your property because other people are negligent in their responsibilities to be respectful of your neighbors. And that's the bottom line, is respectful of your neighbors. And if they're out there and whatever it is that's making a lot of noise, they should realize that the noise travels and they should minimize as much as possible so that they don't irritate their neighbors. But a lot of people nowadays don't care about their neighbors, and consequently, as you've experienced, you've been nice enough to go over there, but they don't care. So this is where the township has to come in, and I believe try the best they can through whatever bylaw we could put through that respects the fact that anybody anywhere in this township of West Lincoln has the right to the enjoyment of their property. And I believe Mr. Treble will be doing further through, again, Chair, to Mr. Treble. Are you planning on bringing this back? I guess you're going to do a housekeeping like we've done on a lot of other items and a lot of other areas in the township where we have housekeeping items come every year. Would this be like a housekeeping item where you're going to go through them? I'm sure there's more than just this area you'd probably be looking at to review.
Through you, Mr. Chair, I guess if that's sort of the wish of committee to do a full review, I can certainly do that. Or I can look at it specific to the issue that's been brought forward tonight. So I'll seek your direction in that regard. What I can say is I've started to do some research on the noise piece. I've also looked at a couple of newer noise bylaws that are out there. But it's possible the one thing we'll have to sort out sooner than later is whether we want to go down the road of having decibel readers and stuff like that. I'm not sure that's where I, as staff, want to suggest we're going. That's a whole new level of, or whole new service level, I think, at that point. But having said that, City of Toronto is one place I have researched where they have done extensive reporting on noise in subdivisions where people feel it should be quieter and the whole bit. And, you know, they've become very sophisticated with some sort of noise measuring device at intersections and stuff like that, and it's able to send out tickets basically by telling the license plate, and we're talking $80,000 or $90,000 a unit kind of deal. So there's the extreme, I'll call it that for now, and I'm looking for other happy mediums before I report back. So I'm not sure the timing, but it'll be a few months, I'm sure.
Okay, thank you. I have Councillor Chicha.
Thank you. I know that recently, as last week, we saw some new legislation coming out where Mr. Ford said that we could put more houses into rural areas on existing farms. And I only bring that up because I worry that this bylaw is going to pertain to urban areas only, because our farm, and I'm not being biased, but in the morning, the manure spreader, the manure cleaning machine goes off, starting diesel tractors, because we haven't yet invested in electric. And I think it'll be long after I'm gone before we do. But that aside, and grain mills are just three things that would have decibel readings that would probably make this sound quiet. So this is something that has to be looked at. Sorry, Councillor Rayner, but out in the country, some of these noises, while they travel well, are going to have to be characterized differently because of at least the distance, unless we build houses, like I say, as Mr. Ford suggests, all over the farms. I would hope that we were looking at something for the urban areas and not necessarily a universal, or are we? Through you, Mr. Chair, to the Director.
I guess two quick thoughts. First, the bylaw is kind of structured as an urban portion and a rural portion. So there's two different sections that you look at depending on where the issue is. The second piece, just to throw out there, is, as I'm sure the councillor's aware, there is something called the Normal Farm Practices Protection Board that protects the farmer and his or her right to farm. So I don't think our bylaw would be able in any way to override what's considered normal to the farmer.
Thank you. Through you, Mr. Chair. I sometimes you ask the question you know the answer to, and I just wanted to make sure that we were looking at it carefully for urbanization, because when you mentioned the City of Toronto and the kind of equipment they have and the kind of bylaws they have, that is much more exclusive to an urbanized setting with a lot of traffic as compared to what we're seeing with hay wagons and combines, et cetera, going down the road. And I think people would understand that. There's a huge buffer, although I wouldn't say that you couldn't hear some of the farm equipment even in town at the peak of harvesting. So I just want us to be practical and deal with the problems we have. Okay, I'm fine with that. Thank you, Mr. Chair.
Okay, perfect. Mary Ganam?
Thank you, Mr. Chair. Through you, I just a couple of comments, actually. One being, if we're going to open up a bylaw, which after 10 years, it's not a bad idea with the changes in town to do that, and look specifically at the wording holes, the things that are there, then I think, if it's the will of council, that we also need to look at the idea of idling. That has been brought to me many, many times through the course of this election time with talking to people. And in fact, I had a phone call recently from a resident who was very concerned about the idling at the plaza, for example, and what that's doing to, to our world, so to speak. She was really quite upset about an issue. And so that's something I think that we need to look at the same time. I know that there's a lot of that going on. And I think if we're really looking carefully, then we also have to examine the fact that there are quads and ATVs and things still around town. They might be coming, out of town, going out to the countryside, or being out already in the countryside and coming back into town. But there's a lot of that sort of going on as well. So if we're going to look, and we're looking mainly at our urban area, then I think we need to look at the language for all of those things and be sort of proactive about some of the problems that are there. Thank you.
Councillor Bell?
I'd just like to say thank you to Ed and Kim for the presentation, well put together, well thought out. And I think that you can pretty much rest assured that Mr. Trouble will look at this and come back with a good resolution. It is a problem. You're not the first people that have mentioned it, but you're the first to come to council with a presentation. So I'd like to thank you for that, and yeah, we'll deal with it.
Perfect. Any other comments? We're good? Perfect. Yeah, I guess I'll just enter a quick comment here. I guess just to echo what's already been said, I certainly agree with that. I think that the biggest thing we're going to look at too, even being a little bit more on the proactive side of things, is our community certainly isn't getting smaller. And so as we grow, this is probably the appropriate time to be doing that full review of what that looks like, and as us just recently looking at the, getting closer to the final approval and the sign off of the urban boundary expansion and what the future of the next 30 years of the municipality is going to look like, the timing of this is perfect. I think this is the right time to be looking at it, and not just looking at it for what's going to be this year, but in over the next 30 years, how can it be effective based on the information that's currently available. So thank you again, Ed and Kim. And at this point, what is it relevant? I'm just going to go to the vote. So,
Is there, could be a motion forward that Mr. Treble could review this? Because there are other things probably that could be looked at.
so I'll just read the resolution again, okay. So I'll read the resolution again before we vote. My mover and seconder is yourself, but that I have the correspondence received by Ed and Kim dated April 11, 2023 be received, and that staff are hereby directed to do a full comprehensive review of the noise bylaw with consideration to notes and concerns highlighted in the PowerPoint presentation presented today on April 11, 2023, and that staff report back at a future committee and or council meeting with a report highlighting their findings and recommendations. So at this point, I'll go to the clerk to call the question there. I just thought you were putting your hand up there. So the vote should be before you. If no one has it in front of you, let us know. Is it just behind? Oh, did the screen go to sleep? Okay. They're just playing peekaboo. If you would like to relay your vote to me, I can pass it on to the clerk. It's okay, so he supports. Okay, and you'll see up on the screens there, the final tally will reveal itself, and that carries. Thank you.
Thank you
thank you
very much.
guys.
Thank you so much. Thank you.
All right, so we're gonna move forward to addressing items on the agenda. Before I read this, let me just take a quick look. So I'll go to our IT. Kevin, can you just let me know if there's anybody in the gallery that's interested in addressing items on the agenda? Please put your hand up if you're interested. I'll give you a second here. And then I'm going to come to that's the virtual gallery. Now I'll come to the gallery before us right now. Have you come up, state your name and address, and then you can proceed with letting us know what item you'd like to address, and then you can go forward and address it.
Thank you. My name is Luciano Piccioni. I'm president of RCI Consulting, and I'm here I'm acting on behalf of Dahan Homes as the agent for their application with respect to item 10.1 on the agenda, which is recommendation report PD-19-2023. I'll try to keep my comments brief.
Actually, just to let you know, so I kind of forgot to stop. I do have to read something just officially, just before you go forward, so that now that we have someone who's wishing to address an item on the agenda under section 1013, 5 and 6, which is known as general rules, 1 hour in total shall be allocated for this section, and each individual shall be permitted 5 minutes to address their issue. Some exceptions may apply. A response may not be provided, and the matter may be referred to staff. A person who wishes to discuss a planning application or a matter that can be appealed can be permitted up to 10 minutes. And then at this point, I've already inquired, so you have 5 minutes there, sir. The floor is yours.
Thank you. I don't see anyone else here, so I guess I could take the whole hour, but I won't. I'll try to keep it to 5
minutes.
I know, I'll try to keep it to 5 minutes. So I'm very pleased to be here on behalf of Dahan Homes. I see some familiar faces around the table, so some of you may recognize me. RCI Consulting, my company, did in fact prepare the Township Brownfield CIP and the Downtown Smithville CIPs in 2010 and 2011. And I've been preparing CIPs across Ontario for over 20 years now, so I'm very familiar with these two plans, obviously. I'd like to start by saying my client supports and agrees with the staff recommendation that the Brownfield Tax Assistance and Rehabilitation Grant applications be approved. As noted in the staff report, this application meets all the program requirements in the Community Improvement Plan, and approval of this application will result in the remediation of a contaminated site in the township and construction of 10 residential townhouses on that remediated site. As this is the township's first brownfield application. In addition to review of the application by staff, an external consultant was retained to provide independent review of the application, and both township staff and the external consultant found the application, including all eligible costs, submitted to conform to all eligibility and program requirements. I'd like to highlight a few key aspects of the application and the staff report. Now, this application was in fact submitted in January of 2022, about 15 months ago, and it was complete and thorough. Now, typical review for this type of application from submission to presentation to council for consideration is usually about 4 months. However, it's understandable that with this being the first brownfield application in the township, the staff wanted to ensure a thorough review and bring in an external reviewer. Unfortunately, that 15-month timeline resulted in my client losing out on a significant upfront regional brownfield development charge reduction, and I'll explain more about that in a moment. Turning to the application itself, remediation on this site is mandatory. It must be done as per the Environmental Protection Act and Ontario Regulation 15304 because the site's contaminated and it's going to residential use. The remediation cost for these 10 townhouses, it's just 10 townhouses, is estimated at $1.28 million, so $128,000 per unit. That's extraordinarily high by industry standards. We typically see 30 to 60, somewhere in that neighborhood. So this is a very expensive cleanup for a small project. That underscores the importance of the Brownfields Tax Assistance and Rehabilitation Grant to this project. Now, while the total eligible costs in the application are about $1.49 million, the actual grant that will be paid to my client by the township and the region, if township council approves this and regional staff approve it, is in fact only about $366,000. And the township would pay about $167,000 of that, or 46%, and the region would pay about $199,000, or 54%. That amount is not paid out up front. It's paid on an annual basis over 13 years as the township and the region collect the increased property taxes on the 10 completed units and then use that to pay the grant. Okay, so after 13 years, when the grant ends, both the township and the region will benefit by collecting the full amount of the new property taxes generated by the project year after year after year. So there's a long-term financial benefit here to both the township and the region. Now, back to that DC reduction issue. Pages 4 and 5 of the report state that environmental remediation costs can be applied against regional development charges. That is no longer the case, as that regional program ended when their DC bylaw ended at the end of August of last year. I did bring that to the attention of staff, but unfortunately there wasn't enough time to make that change in the report. Now, my client fully intended to apply for that regional brownfield development charge reduction program and start remediation before August 31st of last year. And that is evidenced by us applying for the township program in January. But unfortunately, if he had done that, if he had gone ahead to meet the terms of the regional program, he would have been in contravention of the terms of the township program, which require that eligible works cannot be started until council approves the application. So unfortunately, my client lost out on $164,000 upfront regional DC reduction. That's life, it goes on, and he's okay with that, but he really wants to stress that this grant is even more important because of that. Okay, and unfortunately, all the region offers now is a meager brownfield DC deferral program, which really just delays his payment of DCs for a little bit of time. It doesn't really help him out. So, in summary, as noted in the staff report and the external consultants report, this application meets every single requirement of the Brownfields Tax Assistance and Rehabilitation Grant programs. It is supported by staff for approval by council. It will result in the remediation of contaminated site and development of 10 executive townhomes, and it will result in long-term property tax increases to the township and region. So we think it's a win-win both for my client and for the township and the region. And as such, my client respectfully requests that council approve the staff recommendation. So I'd like to thank the committee and staff for this opportunity to speak to this matter. Thank you. I'm happy to answer any questions if you have any.
Perfect. Well, if you hang tight, I think we're going to be addressing it right shortly, so there might be some questions then. And yeah, thank you so much, and you managed to make it under the 5-minute window, so
as promised.
A few seconds to spare. Appreciate that. Okay, so I'm going to move forward As you know, for public that can't see at home, there's no one else in the gallery here. So we're going to move to consent agenda items. There are none today. Communications, there are none. So now we're at staff reports, and it's item P3123, and it's recommendation report, PD 19-2023, Brownfield Property Tax Assistance and Brownfield Rehabilitation Grant Application for land situated on the south side of St. Catherine Street, former CP Dunville Spur Line Lands, Dahan Homes, Inc., Agent Luciano, I'm going to apologize, I'm going to say your name wrong again, Piccioni, I probably butchered that, my apologies. Legal description being part of Lot 56, Registered Plan M88, file number 1519-021-001. And the recommendation is that recommendation report PD 19-2023 regarding Brownfield Property Tax Assistance and Brownfield Rehabilitation Grant applications for the land situated on south side of St. Catherine Street, former CP Dunville Spur Lion Lands, Dion Homes, legal description being part of Lot 56, Registered Plan M88, file number 1519-021-001, and legal description. Oh, I have that twice, I think, in my thing here. I don't think I have to read that twice. Dated April 11, 2023, be received, and that council approve the Brownfield Property Tax Assistance and Brownfield Rehabilitation Grant application for lands located between St. Catherine Street and 20 Mile Creek on the south side of St. Catherine Street, and further identified through this report, subject to the applicant meeting the program requirements, including entering into an agreement with the township, that a bylaw, attachment 3, be passed to cancel all of or part of property taxes in a form as found at attachment 3, and which also authorizes the signing of the tax assistance and rehabilitation agreement, and that the tax assistance and rehabilitation grant request be forwarded to the Region of Niagara for support under their Smarter Niagara Incentive Program, also known as SNP, and that finally, that the building permit fees are waived automatically should approval be granted. So I need a mover and a seconder for that. If I can get a mover. I got Councillor Bradrick, a seconder for that, Mayor Ganan. And so this is officially on the floor here for any comments or questions. Do I have any comments or questions from anybody? Not seeing or hearing. The report's pretty fulsome there. Councillor Chichek.
Just two questions as I look at my notes. Thank you, and sorry, Mr. Chair.
No worries.
I wondered, in reading the report, does the Treasury get involved with this to look at the implications it has on the municipality's budget as we move forward?
So is that to our director
Through
or
you
to
the
our
director.
CAO? Okay.
Well,
so either or.
I would expect that he would have done the discussion, but I'll go to the CAO
Sure.
if she'd like.
No,
I don't care.
I'll start with the director.
So, thank you. Through you, Mr. Chair, as was indicated by Mr. Piccioni, this is the first application, so we were thorough, diligent, and perhaps a little slow, but the departments of planning and treasury worked closely together with guidance from Luch himself, as well as our consultant, Aaron Butler, who's on the screen and can certainly speak to any observations that he had about this application as well. But generally, yes, Treasury Donna has seen and signed off on the report, is aware of the implications, and it was through her guidance that we were able to determine the assessed value of the property. That's where one of the complications and one of the delays came from, was the fact that because this piece of land was tied to the lands to the south, there was no assessed value of the property until just very recently. So some of that delayed the ability to put estimates to the cost of this work as well.
And
Thank
the
you, and
CEO
that
would
was-
like to chime in if you.
But just before we go any
Okay,
further, that
that's
was
fine.
where I was going, was how do we come up with an assessed value without the treasurer being involved? So you've answered that question, and I apologize. Through you, Mr. Chair, to Ms. Henry, I'd be happy to hear what she had to say.
Through you, Chair, to Councillor Chichok. One of the things that I've been stressing since I joined the organization, that is, when these sorts of applications come forward, it's really important to understand the financial impact. I've worked in other places where the council was never presented with the amount that would be become a burden to other taxpayers. And so I think in terms of transparency, it's very important that it be laid out and clear in a report to committee.
Thank you.
Thank you.
And my other question, Mr.
Go
Chair,
ahead.
is I do believe that Mr. Treble was here, but when CP actually was dissolving the need for that rail trail, that railway to continue, they chose to sell it in blocks. And I know that some of my neighbors actually acquired some of that land. And if I remember correctly, this was before I was on council. I was a very young person at this time, so it's a while ago. My memory might be foggy. Pardon me, might be foggy. But we argued against a rail trail that was going to be used for recreational SUVs, et cetera. And the point was that it was very inexpensive land because there was a known commodity, a known amount of, pardon me, issues with it from the creosote on the rail ties, et cetera. So the contamination was known, and it would have been impossible for farmers to buy it, even though it was very inexpensive. And actually, the town of Dunnville bought it, and they took the gravel off and made money on the whole cost of it. I'm bringing this to the point of, if the land was bought at a reasonable price, knowing fully well at the time of purchase that it was contaminated, I just want to know what subsidy really got made when the land was transferred. The ownership came out of CP Rail's ownership when they transferred it to new owners. So if that cost in the actual price of the land was pardon me, considered, then the entirety of the remediation was partially felt in the purchase price. So I really don't want the municipality being, although we will continue to collect for the next 50 years, that should be factored into what we would be giving them as far as the remediation program. I have farmers that cleaned up their own land all the way from Smithville to Dunnville. So
Go ahead.
go ahead.
Through you, Mr. Chair, I'm not 100% sure what I can actually answer that's going to be definitive, but I do know that CP was anxious to sell their spur line lands. They did not want to retain ownership for any great length of time, and were busy disposing of lands when I came to the township in 2006.
That was a long time ago.
It's a couple of years ago. I would assume that Mr. DeHaan bought directly from CP, but I don't know that
He did.
exactly. And I would assume for almost a steal probably back in the day, but that's an assumption.
So through you, Mr. Chair, there's where I'm going, because I know I saw a couple of the deals, because we were going to buy some of it. And I just want to know if at the outset there was some kind of compensation or allowance in the purchase price. That should be factored into any kind of compensation that any government, I don't care whether it's local, federal, provincial, or whatever, but that needs to be a full and fair disclosure. So that's where I sit, because I know farmers who remediated it themselves. So I see that at $1.28 million is a little pricey. There's my questions. There's my concerns, Mr. Chair.
Thank you.
And I just want to make sure that we know all of the facts in this piece of property.
So as I recall, this would have been a sale directly between CP and Mr. DeHaan. I don't think there was a role for the township, as I recall, but Mr. Piccione is indicating that he can probably help answer some of this too, so.
Go ahead.
Through you, Mr. Chair, and I certainly appreciate the point you're making. So in terms of the costs of remediation, they have gone up dramatically in the last 2 years. Tipping fees have gone up by about 40%. Trucking has gone up significantly. Even excavation's gone up. So the anticipated costs have increased dramatically. The other sort of point to that is, so the costs would have increased much more than Mr. DeHaan would have thought, right? The second part of it is, as you said, that should have been factored in. Well, the cleanup costs are in fact almost $1.3 million, but the grant is only $336,000. It's only going to cover 25% of the cleanup costs. So it has been included. If this land was not well bought, I'll say two things. One, if it was not well bought, there's absolutely no way he could do this. And so he does need the grant. And secondly, I certainly wouldn't touch it even, with the grant. And I know a lot of my bigger clients wouldn't. So, he's brave, I will say that, but this is important. And it's not a huge amount of money, but sometimes a few $100,000 can make the difference between making a profit and not making a profit on a project like this. So that's all I can say to that. Most of the applications I do of this nature, the applicants are recouping 75%, 50%, usually 75 to 100% of their remediation costs. So I think it's a win-win for everyone involved.
Appreciate that. Any other members of got Mayor Ganam?
Thank you, Mr. Chair. So again, through you to our director, just for clarification, when this property was purchased, it was all one property right across the creek? Mr. Treble, is that what you were saying? Is that part of the delay, that it was not purchased like north side, south side? It was one stretch of property along the CP line since the line crossed the creek? Is that?
Through you, Mr. Chair, the deed that was conveyed included everything from St. Catherine Street to Town Line Road, including the bed of the creek, which I'm pretty sure he wouldn't have owned.
Exactly.
But-
Well, I
but
didn't
the way-
expect that, but I've
Right.
just, so
But
I just.
the way CP conveyed it, it was one deed.
Okay, because they had one stretch of track, no doubt. So that would explain the delay then, if one piece of the property was being developed. So the south side of the property took a long time to be developed. So actually, this time through you, Mr. Chair, to Mr. Piccioni, I'm wondering about the timeline involved here. Does this clock that says 13 years start if this passes, or does it start whenever Mr. DeHaan gets around to starting to do the cleanup? Like, what from your perspective is the timeline involved here, please?
Through you, Mr. Chair, the timeline is dependent on what's specified in the agreement that will be entered into. And what that agreement states is that the tax assistance, which is payable for up to 3 years, will commence when there's... Sorry, can you hear me now? Sorry about that.
Yes.
It's really hard to see that red light. Anyway, the tax assistance will commence when the property remediation commences. And that will be paid out for up to 3 years. And then the grant will start only once all of the townhouses have been built, the property has been, all 10 units have been reassessed by MPAC, and property taxes have been paid for at least 1 year in full. So the township is never in a position of providing a grant on which, or for which they have not already collected the property taxes. That's all specified in the agreement. There are also performance requirements in the agreement. He has to start the remediation within a set period of time and complete the project within a set period of time. So that's all things that we, discussed and made sure that we're in the agreement to protect the township's financial and legal interests and planning interests. So it's all addressed in the agreement.
Thank you.
Thank you. Councilor Broderick?
Thank you, Chair. Through you to, I believe the presenter would probably be the best one to answer a couple of questions that I have. One being, if the property is not developed, the contamination, is there any danger to the public as it stands right now?
Okay, I'm not the environmental consultant. I'm just the incentive programs consultant, but my understanding is that there is no danger to the public. I mean, this would just be basically creosote, some heavy metals, and so on. But in order to build there and have residential use, it has to be removed to a licensed landfill and done so properly.
Okay, thank you. And my second question, perhaps to the CAO, would be that the approximation for the property tax values, was there any consideration to the fact that it will be built on previously contaminated land versus, or was it a direct comparison to what is on the south side?
Thank you. Through you, Chair, to Councillor Broderick, I might have to ask Brian to assist with this one. I'm not too sure exactly how the treasurer did do the assessment. I'm presuming it would be based on a built structure, built residential, but I'll ask for clarification.
Excuse me, through you, Mr. Chair, I believe it was using the assessed values on the south side and the tax implications from those properties on the south side that we estimated the values. They are estimates, but we believe they're fairly accurate. But the work was done by Mr. Butler, so I would encourage that we get his additional
Sure.
answer to sort of make sure that we're on the right track there.
Mr. Butler, if you can hear us?
Thank you, Mr. Chair. Through you, yes, the post-project assessed value was a direct relation to the assessed value of the homes that were already built on the south side, and on the assumption that the property would be cleaned, remediated to the residential standards that are required.
Okay, thank you. My thoughts were that, there may be a decrease in value when it's known that they're built on previously contaminated soil, that it may affect the value of the home, thus affecting the assessed value. That's all my
Perfect. Thanks,
questions.
Councillor. Any other members? Oh, Director?
Just in that vein, though, through you, Mr. Chair, the south side is the same. It was cleaned up railway land as well. So I think it's a reasonably good comparison that way.
Okay, perfect. Okay, not seeing any others. Councillor Bell?
I just need to get this off my chest because it bothers me the fact that we have a developer that wants to build in the community, which is very nice, and he has built here in the past. He's coming to council, asking council to help front this project on the backs of the taxpayers. And I'm kind of troubled by that, I really am. I just don't see how there's any great benefit to the taxpayers fronting the developer's project. Maybe you can help me with that.
Okay, who would you like? Are you asking the representative?
Yes,
Okay,
please.
so,
Through you, Mr. Chair, so the township actually isn't fronting any of the costs. It's paying the grant in its entirety, as is the region, from the increased property taxes that result from the project. Okay, so in most municipalities that offer this type of grant, they don't even include it in the general levy because it's an add-on that they're actually getting and then giving back in part or in whole. So I understand your concern, but if the project doesn't happen, there is no increased property tax revenue to the township and to the region, and the increase is significant. So after that first 13 years, the grant's done. And for the next foreseeable 50, 70, 80 years, however long those townhouses are there, the township and the region keep collecting that increased property tax year after year after year. So that's the benefit. If you don't offer some incentive, the project doesn't happen, you continue to collect next to zero on it. So I understand your concern, but the mechanics of it, the way the policy was developed, the way it works, is that it's the increased property tax revenue from a project that would otherwise not happen that is used by the township and the region to pay out the grant.
okay, you want to just turn off your microphone, Councillor? Okay, Director?
So through you, Mr. Chair, just to add to what Mr. Piccioni said, the CIP for brownfield lands was put in place by a former council because there could be an instance in the future where land sits idle because it's just too costly to develop otherwise, and hence the reason. It's pretty rare for council to have opportunities to provide incentive or whatever word you want to give it. In this day and age, it's pretty much taboo to do so, but through the CIP program, it is one legal way that's allowed to do that. In those instances where development is not going to happen without that assistance for infill intensification purposes, it was contemplated as the right way to go. What I'm not clear on, and I don't know if this is even an answerable question, but is it possible that this development could go ahead without the grant? I don't know the answer to that. Or is it dead in the water without the grant? I'm not sure if Luch can answer that or not, but.
Through you, Mr. Chair, what Brian's referring to is known in the industry as a but-for test. But for the incentive, would the project go ahead? There's been all kinds of research done in the United States, which has had these types of programs for much longer than we have in Ontario, and they have never been able to develop a valid but-for test. Okay, so the answer is no. There's just no way to know if the project would have gone forward or not. The answer is that some perhaps might have gone forward. But what this does is it helps the project not only to go forward, but to be a better project. If the developer is trying to cut corners just to pay for the cleanup, they may not be able to provide planning with some of the things that planning wants, for example, out of the project. So it's not just a will it or won't it, it's how good will it be if it does type of answer. So we do wish that there was a but-for test that we could fill out and bring to councils and say, but for this incentive, this project won't happen, but there's no such animal.
Okay, appreciate that. Councillor?
Just on Brian's question, you answered his question, but you referred to the states. What about Canada? Let's talk about Canada, that's where you're going.
Well,
Certainly.
I think he was just referring to like the closest
I
comparable,
realize-
but I get what you're saying.
But is there anything in Canada that's comparable?
Through you, Mr. Chair, nothing. There is no but-for test. And I've read all the literature, I've done all the research there is to do. And a few have tried, but the but-for tests have really failed. The other thing I will add is that the program itself, with all of the requirements, the general program requirements, the specific eligibility requirements, is designed to weed out those projects that don't need it. So there is that also to take into consideration.
Okay, appreciate that. All right, not seeing anybody else. I just have a couple questions myself. I'm going to go to the director. We heard about the timeline, and so it's not unfamiliar to council that timelines aren't always met. What is there in terms of protection for the municipality should these timelines not be met? So once things start rolling, we had a development not too long ago where I think the solution ended up being blocking off a portion of land that was contaminated was the quick and dirty solution of solving that problem. And in this situation, I just want to make sure that if this were to start in any capacity, that it actually sees completion on a realistic timeline. So I just want to understand the full scope of what the penalties look like. Is there penalties, and how do we go about enforcing that?
Through you, Mr. Chair, there's one piece I'll mention, and then I believe Mr. Butler can probably confirm some of the timelines and control mechanisms as well. And I'm just dying to say the Butler did it in the study with a pen. So I'm just dying to say that. Sorry, Aaron. Anyway, the one piece that we have control over was the fact that in December, I believe it was, if my memory serves me correct, we extended draft plan of condo approval on this property for 2 years. So we've got a 2-year window within which they can meet conditions, get agreements signed, and proceed. Should they fail, we could refuse to grant extensions into the future, which means it stays as raw land at that point until a new application comes along. But certainly the draft plan approval of 2 years is the one piece that we have here. And then I think Aaron also has some clarity with respect to timelines as well, if I can suggest we turn it over to him.
Thank you, Mr. Chair, for the question. As I'm reading the agreement, which was drafted by Mr. Richardson, your solicitor, clause 319 of the agreement says that the works essentially have to start within 5 years and be completed within 7 years of the execution of the agreement, or else no grant payments would be made to the owner. And the owner may also kind of be incentivized to do that sooner, and for sure get approval sooner with the regional programs and any agreements that they enter into with the region.
Okay, so my question to you, sir, is, so let's just kind of, it starts, okay, let's just say it starts within the timeline needs to start. What, they come into a situation, a hypothetical situation where it's a lot worse than they had originally assessed it at, and it's now more complications have come up for, let's say, things beyond their control. What actually forces them to complete the project? If they have to complete it within 7 years, my understanding is that it's already got the ball rolling at that point. You might understand that no money is given to them if they don't complete it at that point, and then they're on the hook for the whole amount?
That's correct.
Okay. Oh, go ahead. Go ahead, kid.
Through you, Mr. Chair, I believe Mr. Piccioni has some additional information that might be interesting.
Through you, Mr. Chair, just to add to that, so the must be commenced within 5 years and completed within 7 years is the actual construction component. Clause 3.7 says, in the event that the accepted remediation works are not commenced within 1 year of approval of the tax assistance bylaw, this agreement shall be at an end, and no tax assistance shall be provided to the owner.
Okay.
So they have to start remediation within 1 year of passing of the bylaw. They then have to start construction of the actual townhouse within 5 years and complete within 7. They miss any of those deadlines, my client misses any of those deadlines, this is all at an end.
They're out of luck. So my last question to you, Mr. Director. Should council pass this evening, does this prohibit or prevent any other applicant from coming forward with a chance of success? So like I'm going to use, one of the things I think we as councils are trying to do is we're trying to encourage more commercial and industrial growth. You know, we want to see more opportunity for childcare facilities and another physician center to address some of the growing needs of our community. Does this hinder that in any capacity? Does this overload it in some capacity? Will this impact future decisions?
Through you, Mr. Chair, as was explained by Mr. Piccioni, I think generally we're giving back money that we never really anticipated through our budgeting process anyway, so I don't think there's necessarily an impact to the bottom line in terms of our operating day-to-day. And so I think we should be able to look at each application on their own merits, and as I heard Mr. Piccioni say, each one would get weeded out if it didn't meet the various tests of the study and its commitments. So my thought is if another one comes along, we'd give it a thorough review, probably hopefully meet the 4-month timeline as opposed to the timeline we're on with this one, and be providing reports and recommendations around whether or not that one's qualified and appropriate. The good thing is, though, Mr. Chair, we don't have a lot of brownfields in this township. Okay. So the likelihood of an influx of applications is different than, say, the city of Welland, where they have significant issues. We do have the odd one in our downtown core. We have a property just across the creek on the other side of the bridge that could very well be in someday, and, you know, there's a few others like that, but there's not a lot of them, so.
I appreciate that. In that area, like, you know, obviously I'm not an engineer, but, you know, for 10 units, it certainly seems like a lot of money to be having to deal with, and I appreciate the presentation. I appreciate everyone's information. Yeah, I'm not sure right now, but still, at this point, I'm looking around the horseshoe. I'm not seeing any other questions, so I'll log on here and then I'll ask the clerk. Sorry, my thing timed out. To call the question. Hold on. All right, so at this point, I'm going to have the clerk call the question. Who are we waiting on? All right, we're just having a little, who are we waiting on right now? So we're just waiting on Councillor Chichak right now, so.
You're not going to get it by the time I get there, so it's the vote.
That's opposed. Okay, you'll see the tally up at the screen here. Oh, and that is loss. All right. Thank you very much for your presentation, sir, and wish you all the best. So at this point, we're going to move forward to the next item on agenda. Item 3223, and that's, let me make sure I'm not double reading here. All right, 3223, it's recommendation report, PD 18-2023. That's the application to remove the holding symbol, DeHaan Homes, Inc., crossing on the 20 North. That recommendation report, PD 18-2023, regarding recommendation report, application to remove holding symbol, DeHaan Home, Inc., crossing on the 20, file number 16010922, dated April 11th, 2023, be received. and that a bylaw be passed to authorize the mayor and clerk to remove the holding provision on the subject lands as identified in the attached bylaw as attachment 3. So I need a mover and a seconder for that. I got Councillor Broderick and Councillor Trombetta as a seconder. And any questions or comments? Not seeing any, so I'll go to our deputy clerk here, to call the question. Sometimes I just speak too fast. All right. Oh, I can't see.
It isn't coming up, so I will indicate my vote manually.
Still not coming up. Who are we waiting on? All right, so Councillor Chica, I'll need to know your support. She supports. Perfect. All right, vote will come up there, and that carries. Thank you for that. We'll move to other business. So it's item P3323. Make sure I read that correctly. P3323, last one was 32. Okay. And that's the official plan amendments 62 and 63, Regional Council verbal update by our director.
Mr. Hayworth was actually in attendance in person, so I'm going to have Dave give you a brief
apologies.
update. No, that's okay. It's under my name.
Okay. Mr. Hayworth?
Thank you, through the chair, to the committee. The applications were presented to Regional Planning Committee, both OPA 62 and 63. They were approved, I believe, unanimously, so strong support for the applications. There were some questions, nothing of a major factor. Our consultant, Steve Weaver, did a great job in his presentation. The mayor made some strong remarks in support of the applications as well. And I thought they were well received at the committee. I think it's an example of the township staff and council working collaboratively with the region throughout the whole process, starting in 2019, in order to plan for growth in West Lincoln with a made in West Lincoln solution to how that growth is accommodated.
Excellent, thank you. And yeah, I'll mention as well, I think we all can express our thanks for the unanimous support from the region as well. It's great to have a good working partner in this. This has been a, as our director could say, a long road and many hurdles to come, but just 1 inch closer and to seeing this become a reality. So that's fantastic. Assuming there's no other questions or comments, I'll move to item 3423. That's the Ontario Land Tribunal appeal, Mother against Wind Turbines Inc., and it's Ontario versus Ontario Environment Conservation Parks. It's just a verbal update as well. Go to our director.
So through you, Mr. Chair, just to give a committee update, the last time this was scheduled for a hearing, it was adjourned because of the fact that inadequate notice was given and the timeline was basically too tight. It still seems very tight in my mind, but notice has been received that a case conference is being held tomorrow, April 12th, and notice just came out last week, so it hardly seems like adequate notice still. And I noticed that if you want to speak, comments had to be, or the request had to be made by last Wednesday, the 5th. So anyway, it's scheduled. This time, though, I will say the notice is much better worded in the sense that it says very clearly it applies to Turbine 8, and it gives the address as 7320 Concession 3 Road in West Lincoln, and it's clear what it's about. The last time everyone was calling saying, we don't know what's going on, or there are more turbines coming and all sorts of stuff. So, to give them their dues, they have improved the notice wording dramatically, and hence we did not get nearly the calls at the office this time. But so just so you're aware, it's scheduled for tomorrow.
Appreciate that, thank you. And we'll move on to item P3523, members of committee, other business matters of informative nature. Any members? I'll mention real quickly, just I want to thank staff for the for all the festivities over the weekend there. We had the Easter hunt on was it the Friday, and then Saturday they did the Easter market. I was able to attend both. I saw Mayor Gannon and Councillor Chichuk at both as well, and it was really well received. I think the only feedback I got is people were hoping for more chocolate, but from what I understand, there's a bit of a shortage in the chocolate egg department, but otherwise everyone was pretty happy and pleased with that, and we had a beautiful weekend for it as well. So other than that, any other members of committee not seeing or hearing any? Any new item of business? Not seeing or hearing any of that. We have a few confidential matters, so I'll read that. That the next portion of this meeting be closed to the public to consider the following pursuant to Section 239(2) of the Municipal Act 2001. And under 13.1, Director of Planning and Building Brian Treble, Legal Solicitor, Client Privilege, Legal and Bylaw Enforcement. It's a verbal update. The applicable closed session exemptions are litigation or potential litigation, including matters before administrative tribunals affecting the municipality or local board. Advice that is subjected to solicitor-client privilege, including communication necessary for that purpose. And personal matters about identifiable individual, including municipal employees. The next item is 13.2, Director of Planning and Building, Brian Treble as well, and it's the legal solicitor-client privilege insurance claim matter verbal update. It's applicable closed session exemption. Our advice to the subject, advice that is subject to solicitor-client privilege, including communications necessary for that purpose, and litigation, potential litigation, including matters before administrative tribunals affecting the municipality and local board. And then lastly, we have another matter under 13.3, legal solicitor-client privilege, Ontario Land Tribunal, Helen Kazan, file number 22 -00280. It's a verbal update, and its applicable closed session exemptions are advice that is subject to solicitor-client privilege, including communications necessary for that purpose, and litigation or potential litigation, including matters before administrative tribunals affecting the municipality or local board. So I'm going to need someone to move and second that. I got Councillor Rayner and Councillor Bell. Oh, it looked like you moved your hand there. I saw your hand move up there. So are you withdrawing your hand moving up there? All right, so he's removed that. So I have Councillor Braderick as the seconder. I'll push Councillor Bell to the mover. And all those in favor? Bell, yeah, because I thought I saw Councillor Rayner put his hand up. I was going to say, I've never seen your hand move so quick. All right, so this is to go into close.
We're going to talk a bit about Friday, but I told Richard I'd set up a meeting, try this week, I think Friday afternoon. Because the next meeting next week.
And then once the votes
No, the 20.
cast, we'll be back shortly for those who are watching at home.
Let's try and set something on Friday afternoon.
Well, if we don't go through, the meeting's pretty much done. So.
We got the two consents, so.
Oh, and she supports.
Variances have to be on the end of this week. Yeah, so we're good.
We are officially in close, so we'll be back. Thank you.
You don't need me.
Welcome back, everybody. I'm going to mention that the committee now resumes at the open hour of 8:51 PM. I'm going to get a mover and seconder. I have, or what did I say?
8:51.
All right. We'll back that up. 7:51, an hour did not pass. I have Councillor Chichuk and Councillor Bell, and then I'm going to, now we're back in open, right? So do I take a vote? I can't remember. I'm flustered right now. Okay, all those in favor of going back in the open session? And that carries. I see Councillor Rayner supported that time. Well, I figured you didn't want to stay in close. Okay, so I'm just going to read what we have here. So under item 3623, solicitor-client privilege, legal and bylaw enforcement, we received an update. Under item 3723, another legal and solicitor-client privilege, insurance claim matter, a verbal update. And then lastly, under item 38 or P3823, legal solicitor-client privilege, Ontario Land Tribunal, Helen Kazan, file number 22-00280 was a verbal update as well. There's no other business or anything else to deal with this night, so I'm going to adjourn the meeting at 7:52 PM. Have a great night.